I'll do a land acknowledgement, a comment that we are on the land of the Coast Salish people. I am in Seattle, and acknowledge that this is land that has been taken care of by the Snohomish, I'm sorry, the Duwamish, the Snoqualmie, variety of the different tribes for thousands of years, people who are still here. And the way to show support and acknowledge not just that we're on stolen land, it's also to support some of the land back movement. Invite you to explore that. I invite you to consider supporting the Duwamish with their real rent program, and recognizing in daily activities that we are on land that's been taken care of for thousands of years by the original people. And once again, thank you to the Washington branch of the International Dyslexia Association and Decoding Dyslexia for bringing us this event tonight. And I am going to jump right into it, and I will hand this over to Nicole. Thank you, Nicole.
Thank you, Sherilyn, and thank you all for having me here tonight. My name is Nicole Monero, and I'm a special education attorney. I've been in practice for 16 years. Prior to that, I was a teacher in the public schools and have a master's in education. I'm also the board president of Attorneys for Education Rights and participate in policy and legislative advocacy for reforms in special education law, including the bill that we're talking about tonight. As a housekeeping matter, while I am an attorney, I am not providing legal advice tonight. So this is just for educational purposes only. So with that, I'm going to go ahead and share my slides with you. Okay. So I'm going to start with the actual bill itself, Senate Bill 5883. This is the new law that has been passed, changing the burden of proof in special education due process hearings. So this is very exciting reading to have by the fireplace at night. I'm not going to read it to you, but I wanted to let you know that I've highlighted parts of the bill here that I'm going to be talking about with you tonight. So we're going to go to law school. And this has been signed by the governor. And as we've said, it's going to go into effect on June 6th. So there are three parts of this bill that I'm going to go into tonight. The first part talks about changing the burden of proof to school districts, what kind of burden that is, and what due process hearings are about. The second part is an exception to the rule and when parents will still have the burden of proof in a due process hearing. And the third part is the standard that the judge is going to apply in a due process case to the evidence. So what does this all mean, unpacking all of that legalese? There's a lot to unwind. So this is how I'm going to go through it step by step. First, going to the foundation, I'm going to talk about what a due process hearing is, what it's for, and what a parent's right to the due process hearing is. Next, I'm going to talk about what the burden of proof looks like in practice. I'll also touch on the history of this and why we in the advocacy community fought to change it. And I'll talk about the implications of this new law. So what are due process hearings for? What is their purpose? So due process is meant for parents to enforce the rights of the child under special education law. And the centerpiece of that, of what the child has the right to receive, is the education laid out in the IEP, the Individualized Education Program. When things are working the way they are supposed to, the school works with the parent or the guardian to create this program, to create a plan to meet the needs of the child. The IEP is the guiding legal document, the individualized education program. But we see barriers for many parents in understanding what the school is doing, and in being a true partner with the school in creating this plan. The law, the Individuals with Disabilities in Education Act, that's IDEA, says that there are two very important things that schools must do. Number one, provide a free, appropriate public education, FAPE. And that's one of the foundations of this law that's individualized to the child, and it is to allow them to make progress according to their circumstances. Now, number two is the cornerstone of this is meaningful parent involvement and participation in every step of the process. And so IDEA law, special education law, is about protecting parents so they can enforce the rights of the child. And the right to a due process hearing is part of that. So why request a due process hearing? The reasons why a parent may need to request a due process hearing come up when the system is not working the way that it should be, the way that I've described. So parents do run into problems when the school presents the IEP, the Individualized Education Program, as their domain, rather than partnering with parents. And so we see lots of people at the table. We see lots of jargon being used. There are specialized tests and a lot of paperwork to interpret. And it's just presented to parents without explanation and not as a collaboration. So another area where parents and schools may not agree, the law says that an IEP must provide a child with as much access to general education as possible and appropriate for them. So this means being with peers without disabilities and the curriculum that all children in the state are supposed to receive. And also that the child is supposed to be making progress on that IEP according to their circumstances. Another area where there are disagreements that rise to the level of a due process hearing is where that IEP is not being followed, where the child's needs are not being met year after year. If parents can't work it out with the school, they need to go to an outside, unbiased decision maker to decide and order a solution. And this is how legal rights are enforced in our state by parents and how their voices are heard. So it is important to know that the state that oversees school districts doesn't know there is a problem oftentimes until parents exercise their rights. Since I've handled many due process cases over the years, and I read the due process decisions that come out, I see many of the same patterns. So we often see problems that happen over years at a time and not just a one-time situation, where what's happening is the child is not making progress, and then the plan doesn't change in response to that. This can look like goals being cut and pasted or repeated year after year, and the student may still be reading on the same grade level or not mastering the foundational skills that they need to learn. A student may have learning disabilities that are never properly evaluated or addressed, and their plans only focus on their behavior instead of what the true needs really are. We often see problems with school discipline, and what also comes along with that is restraint and isolation. This can also look like the parent being called to school every day to pick up the child early, children being repeatedly sent out of class, lots of emergency suspensions or expulsions. Other disputes are over districts changing a child's program without agreement or collaboration with the family. We may see a child that needs a specialized program, and the school may insist that they don't see any issues and that the child doesn't need one. When these things happen, families do not feel heard, and at the heart of it, the relationships break down and the school staff stop collaborating with the family. So this brings us to the legal right that parents have if they do not agree with what the school has done. And so the due process hearing system is given to them by special education law, where a parent has the right to request a due process hearing over virtually any part of the special education system, from failure to qualify a child for an IEP when they need one, a failure to properly evaluate the child, the IEP itself, inappropriate discipline, and more. They have the right to a hearing in front of a neutral, unbiased hearing officer. And in our state, that's called an administrative law judge. The administrative law judge works for the Office of Administrative Hearings. So these cases are not heard in a courthouse. They're not in front of a jury. They are more similar to a Social Security hearing or an unemployment hearing or things of that nature. And so when the hearing takes place, there is the administrative law judge, the ALJ, in the room, the court reporter, parents, a representative of the school district, the witness testifying, and the attorney or attorneys present. And in the old days, these all took place in a conference room, usually in the school district, and now they're mostly taking place on video. Parents have the right to call witnesses to present evidence, and they can cross-examine just like a trial. The school district always has an attorney, and the parent is not provided one, and they have to find one. But access to justice in our state is a barrier, and parents often have to face this process alone. So the new law talks about changing the burden of proof, but where does that come in this due process hearing system? So burden of proof means which side has to show that the other side broke the law. It used to be that the parent had to show that the school district violated the law. The district did not provide that free, appropriate public education. Now, the district has the burden of showing that it followed the law. And there are two parts of this that the law talks about: production and persuasion. So number one, production means showing that this happened with documents, with the evidence, and with witnesses testifying. Number two, persuasion means that you have to persuade the judge that the district broke the law, where now the district has to persuade the judge that they followed the law. So now this means that the district has to do these two things: produce evidence and persuade the court that they did not break the law. And that means that the district has to show its work. So the next part of the law talks about preponderance of the evidence. And this part is about what standard of evidence the judge will use to come up with their decision. So this is not the same as criminal law. And what preponderance of the evidence means is it's like a balancing scale. And so it means more probably not, more probably true than not true, or more likely than not. This could even mean something like more than 50% likely to be true. So this is not the same thing like on Law and Order in a criminal case where you have to prove something beyond a reasonable doubt. What this means now is that what the district needs to show is that it is more likely true that their plan was implemented, that their plan was appropriate, that the child is making progress, and they can't just say that anymore. They have to show now. Next, I want to talk about the exception to the law. And there is only one now, just one narrow exception, and that is the exception to the rule where parents will still have the burden of proof if they put their child in a private school because of the legal dispute and they have requested a due process hearing over being reimbursed for that tuition. So this exception came to be because the assumption is that the parent will have the records from the private school and the parents and the new school will know more about how the child is doing and why the new placement is more appropriate. So in this sense, the parents will still have the burden of proof in this type of case. So now that I've talked about what the law means, I'd like to go into how this change came about and why this change is so important. So years ago in our state, districts did have the burden of proof, but then there was a Supreme Court case back in 2005, that's the Schaefer versus Wiest case, that changed the default rule nationwide to that the party who is raising their concerns, and that's the parents, would have to bear the burden in a due process case. And then the Supreme Court left it to the states about whether they wanted to change it. So there are 6 other states that did change the rule back, and now we are one of them. In the states that changed this rule, they have reported that more cases are resolving and that there is an incentive for the school district to work things out with parents. And in our state, a lot of advocates worked together for years on this. Advocates banded together to file a petition to OSPI to change the rules. They've sought sponsors in the legislature to bring a bill forward to try to convince them that this has been an unfair rule for families, to try to go up against large government agencies to fight for the civil rights of their children. So why was the old rule unfair and why change it? So school districts have everything at their disposal because they are there with the child every day. They have all the records and all the evidence, and the judge considers all of the school staff, the teachers, the principal, the special education director to be knowledgeable experts. School districts have taxpayer-paid insurance that pays all their costs for due process hearings and pays for their attorneys. Families have to take time off work, whereas teachers are given paid time off work to come to the hearings. There are language barriers in accessing this system in the first place. There are income barriers, and families either have to pay for their experts and attorneys, or find legal services to represent them. And I want to say a word about paying for the experts. So under this old rule, the judge was assuming that all the school staff are experts, that they are the educational experts and not the parents. And they expect the parent to present their own expert, like a child psychologist or a specialist, to show that the school is wrong. And they expected the parents to have someone who observed the child in school to persuade the judge. And these experts cost a lot of money for their time to work on the case, to evaluate the child, and to write a report and testify. And this is all because the parents are not in the classroom. So otherwise, they don't have a way to show to the judge that the district broke the law. They know that there's something wrong, but the next step is how do you prove that? Another unfair part of this system is that parents mostly don't have attorneys in these. And there are many reasons why access to legal representation is an issue in our state. And because of this, it has been easier for districts who know that parents are facing this uphill battle to just wait the parents out and delay for a long time, knowing how hard it would be for a parent to meet this burden. And in the end, who is really hurt is the child. So I cannot stress enough about what a huge change that this is. And I'd like to talk about what some of the implications might be and what we are expecting on the horizon. The change might not take place right away, but I think over time, this is what we're going to see. And so really now it's the school districts have more at stake. So they will be, and they should be more motivated to work things out with families. In the due process hearing itself, parents will get more access to the information because districts have to show their work to the court and they won't get away with hiding it. We predict now that there is a better chance for transparency because districts will know that in the event of a dispute, they are really going to need to demonstrate that the child's needs are being met. I find right now often schools are not keeping data and are telling families that the child is making progress and doing all right, or that they aren't seeing any problems at school. But this is a huge problem. And in the event there is a future dispute, this is not going to be acceptable anymore for a school to be able to defend its program. It will need to show that data. We do predict that schools will try harder to avoid disputes with parents if they know the burden is on them to defend their own program. So as this law is enacted and we see over time, we should be seeing a greater willingness to share information with parents and to work harder to resolve disputes so to stay out of court. So finally, this really levels the playing field for parents in our state. We still do not have a lot of attorneys who practice in this area of law. We have civil legal aid providers, but our capacity is not huge. So there are a lot of parents who are going to need to navigate this system. And it is more fair for the school district, who is a government agency with all of the resources and advantages at its disposal, to carry this burden. So I'd like to stop there. I've tried to leave a little time for questions if we don't have time now. We could also have time at the end to answer them before I turn it over to Cindy Dupuy. So I'm going to.
Not seeing any. Oh, we do have a question in the chat. Impacting what would be able to be considered adequate evidence of progress will be interesting. We still see Fonteness Patel's levels being used as metrics. I'm going to talk a little bit about that in the next piece. Nicole, how will it change to get districts to produce records for due process?
So we know under the law that parents are required to be provided the records in due process, and truly any parent has the right to get their records before any IEP meeting, and we know in practice that's often a big fight. In a due process hearing, it will be to the disadvantage of the district to not show any records because they're the ones that have to prove that the child made progress. And so what we're seeing in the past with hiding records or producing them at the last minute will only hurt them. It would make no logical sense for them to do that in a due process hearing.
With this being a procedural change for hearing rules, will this cover action prior to the effective date, as long as the hearing is after the effective date?
Yeah, so that's the million-dollar question. Parents' attorneys are trying to brief this to the court right now to ask them to clarify. So the lawyer answer is we don't know yet, and we're waiting. I would think it would be the most fair to just apply the rule that's in place at the time the hearing is held, but we're not being given that clarification yet.
How do you think this law might affect the standards of quality for NPA and district contracted schools, if at all?
Well, one thing that I think school districts need to be reminded of, and we've done a lot of work with the state on this, is that school districts are responsible for kids that are in NPAs. They do not stop being public school district children when they go into NPAs. And it's not right for that monitoring to not happen. And so if districts are also continually held to that standard that they're, a non-public agency, a private school where a child is placed by a public school district, paid for by a public school district to receive their special education services. Those children are still supposed to be under the supervision of the school district, and the school district is responsible for the education that happens. And so they're going to have the burden to show that this is appropriate too.
There's a question about being able to file a due process if you have filed a state complaint, saying that if you have filed a state complaint, then you can't file due process potentially. Is that something you want to get into, or?
That's super complicated, and I want to make sure I'm not giving anyone legal advice on their cases, as I'm not allowed to do that tonight. Community complaints are a totally different process than due process. The Office of the State Superintendent of Public Instruction, OSPI, handles those, and they have rules about how they handle it, and they will tell parents about how they will handle that case if the parent also filed due process. So I can't go further than that.
Somebody asked if ALJs will be getting training, and I'm assuming that that's going to be some ongoing discussion. Is that your thought?
So I would love to have a part in training the administrative law judges. Part of my organization offers training for attorneys, and we invite the judges to come. And so I have done some training, but it's not clear. I'm I've been told by the judges that they're having roundtables about this, and they're all meeting weekly, you know, but I don't know further than that what official training they're receiving.
And I'm trying to look at global questions by people. I think there's a couple that are kind of going deep detail. There's questions about students who have not been identified for special education. Does this cover them as well?
Yes, absolutely. So if a parent feels that their child should qualify for special education, and the school has refused, they have a right to bring a due process hearing about that.
And so we're specifically not answering very detailed and specific situational questions. So I see a couple popping up, and we're gonna kind of give bigger, broader answers. So I think that's kind of the last one that I'm seeing pop up at the moment. That is not super specific. So I'm hoping we have a couple minutes after I'm done. So if other questions come up, we can take those at that time. So that sounds like a good place for us to transition. So
take it away, Cindy.
Okay, so I am Dr. Cindy Dupuy. I have a unique background coming to this. I have a master's degree in secondary education, so I was a certificated teacher with endorsements in chemistry, science, and special education. And then I have a PhD in learning disabilities. And I am in private practice doing diagnostic evaluations, and I provide advocacy for parents, and I've served as an expert witness in a handful of due process cases. And so I'm that expert that you've had to go find to come in and help the judge understand what's going on. What I want to talk about a little bit tonight is how do you begin to structure an IEP so that the teacher has an easy time generating data that will be usable by everybody and that you're adequately covering the child's needs. So let me pop this up. It is not, there we go. So that is just the same heading that we have. So an individualized education plan is intended to identify specific skill sets in a student that we want to change in terms of their academic performance. And there are three things that make a good IEP goal. They are quantifiable, they're measurable, and they're ambitious. And we're going to walk through each of those areas. So quantifiable is coming in and saying, what specific target behavior are we looking to change? I often oversimplify this to give parents an idea of how to wrap their minds around it. Of if I had a dog, what would I want the dog to be able to do? I want my dog to be able to sit on command. That is quantifiable. I want them to sit within a certain period of time. Simple form of that. So when we start talking about kids in an academic environment, we're talking about, I want a student to be able to read real and nonsense words, knowing how to decode them accurately. Or I want my student to read a passage and be able to answer literal and inferential questions about what they've read. So I'm identifying the very specific academic skill set that I want them to change. So a quantifiable goal is also specific. It targets a very specific academic area. And we're going to see an example of a goal that doesn't do that at the end. But we want to know exactly what we're working on and where we're trying to go with that. It also needs to be appropriate for the student's academic needs, okay? And we're going to talk about that in a minute. okay? Measurable means we have to have a way that we collect data that somebody else can pick up and then interpret. So for example, I will write a goal that says a student will read 95% of words on a word list, or they will read at a certain reading rate and a certain accuracy, okay? And we can actually embed that measurable part within the goal. Some of you have probably already seen this if you've had goals written. Sam will answer questions with 85% accuracy, or Joe will improve his ability to decode words in whatever rate and accuracy, okay? We want the measurable part of it to measure exactly what we're talking about, okay? And again, we're going to look at that in a little more depth. And then the other key piece is that a goal is ambitious. So when I see somebody write a goal that says at the end of an academic year, a student will be able to solve 10 long division problems with 90% accuracy, I go ballistic. To me, that is so narrow and so tiny, we're not adequately making that student grow. That is a skill that is taught in a matter of months in a general education environment. And we're saying that's what we're going to do for the entire year. And to me, we're not grabbing enough and taking on enough to make that student grow enough. Because the ultimate goal of special education is to get the kid out of special education. Originally, when they were thinking about special education, it was you're going to be in there for a couple of years. We're going to address the academic need, and then you're going to move back into the general education classroom, and you won't need specially designed instruction anymore. Okay. We also need to not be outrageous, meaning I can't expect a student to make 4 years progress in a year. Okay. So we're looking for a sweet spot of growth over time. Okay. So I went back in some old IEPs and I pulled up a present level of performance for this particular student. And just like Nicole did, I'm going to show you now kind of the critical pieces of that text. And so the key pieces in here is that the student had difficulties with phonemic discrimination. So they couldn't hear the difference between the S sound and the Z sound, okay? They had problems with word reading, so they didn't have good word recognition. They couldn't apply the rules of phonics to a word they had never seen before. So they didn't know the letter sound correspondence, and they didn't know how to apply it to a novel word. And then they were below grade level in reading comprehension, fluency, and basic reading skills. And they said they struggle with decoding of basic words. So this has given us a great list of specific details of things that we need to work on. So one of the big problems that we have with this prior goal is we're missing grade level. So this student, and I apologize, I skipped over this, is in the 6th grade and they're 12 years old, okay? So when they're coming in and saying the student is below grade level, we don't know how far below grade level they are because we have no grade level metrics, okay? I will tell you, based on the description, that the student is at a kindergarten or an early 1st grade level, okay? So they're very, very far behind. The school is saying they're below level in reading comprehension, but they haven't identified the floor, meaning where do we have any reading comprehension skills? So when we don't have that data, we need to go back to the school and say, we can't write a goal right now because we don't know where we're starting. So I need you to go back and identify what letter sound correspondences they have, their overall accuracy in decoding, et cetera, et cetera. Okay. And I keep admitting people. All right. So all of this, by the way, as we're talking about this, is built on the tenets of structured literacy. And the tenets of structured literacy build all of the elements that we need to become a fluid, comprehending reader. And we'll go into more depth in this in another presentation. Just know it's there. This is super important. But we have to have these key pieces if we're going to build the students' reading skills. So what do we want to measure based on that student's performance? So I would want to see the student have an assessment of what letter sound correspondence they knew and what they were missing. So one of the documents that we have for everybody is a scope and sequence that I've written up for a ton of academic areas. So I've got a scope and sequence for what letter sound correspondence. I've got a scope and sequence for syllable types and rules of syllable division, et cetera, et cetera. So I've broken it out so it begins to give you a way to quantify where your student is at. And I'm going to give you some ideas right now of how could you better characterize it yourself, okay? So there are a couple of tools that are inexpensive and available to parents. So a great tool is the Wilson Assessment of Decoding and Encoding, which is called the WADE, and it does all the letter sound correspondence. It does simple CBC single syllable words like cat, dog, run, all the way through very complex words. It also does an encoding and a spelling component. It also includes reading nonsense words. So it gives you all of those foundational pieces of reading. Another powerful tool to look at reading fluency, so that would give you all of the letter sound correspondence and decoding. For reading fluency, there's a tool called the Qualitative Reading Inventory. It's on its 7th edition. There is absolutely no reason not to go back to the 5th edition and buy it on a major retailer's website for about $6. And it literally gives you multiple passages to have your child read aloud. It gives you word lists to have your child read aloud. It gives you reading rate and accuracy. It gives you literal and inferential questions. And it tells you whether your student is at a instructional or proficient level. It gives you all of those elements and it tells you how to administer it, okay? So it builds in all of these pieces and lets you actually get to that reading comprehension piece. So knowing that we don't have that exact piece, we can come in and say, if the school district came in and said that the student was reading on a 1.2 grade level, first year, second month of first grade, an ambitious goal would be to gain a year and a half of reading level, and we want a particular reading rate, also in that scope and sequence document, with at least a 98% accuracy, okay? In reading comprehension, we should look at a year and a half growth with at least 80% accuracy for literal questions and at least 75% accuracy for inferential questions. Literal questions are what can you pull quoting from the passage, and inferential is about drawing conclusions. So now that we've kind of broken all of those pieces out, I want to show you the goal that was written for this student based on that present level of performance. And I skipped over it. Where did it go? Here we go. They wrote, when given an unfamiliar passage or story, blank will identify the 4 W questions: who, what, where, from the text, improving recalling of facts, from 0% accuracy to 70% accuracy as measured by staff data collection and observations. So I would point out that this is not quantifiable particularly well because we don't have a grade level. We don't have anything around the decoding piece. We don't have anything around phonology. We don't have anything around reading fluency. And the only thing that we're assessing is this small characterization of the main W questions within a text. So it's a very limited goal and it doesn't adequately cover what this student actually needs. Okay. So, when we write good, quantifiable, measurable goals, well-written goals can produce obvious work samples that you as a parent can then see and review. So if I write a goal on decoding, that instructor should be able to produce the list of words and show me which words the student read correctly. If I'm working on reading fluency, they should be able to show us the passages that the students read aloud with the reading rate and the number of errors that they made. If they're answering questions about the passages, comprehension questions, they should be able to show us which ones are literal, which ones are inferential, and how many of those questions they got right. So the goal itself then creates that data so that you as a parent can see what's happening, and the teachers have a really concrete way to think about how they're going to collect the data and then present it. And I have no idea of what time. Oh, I didn't do too bad on time. So I am happy to take questions now.
And this is Sherilyn. I'll just say we will have a hard out at 8 for our interpreters. So that was it.
Okay. I will also say Heather and I are going to do a presentation this fall on IEPs together. So we're going to come back and kind of take this apart a little bit more. What I see one, what is this? What is the school would not explain the data at all and would not complete the data in any way a parent can understand? So this is where the change in the law becomes such a significant feature. The school is going to have to be able to demonstrate that they have adequately implemented the goal and the student has made change and growth. And if they haven't, you'll be able to then you'll be able to better advocate and get the instruction to change to better meet your students' needs. This is 100% exactly the same for math goals. And I did include scope and sequence for math in my document. Okay. I'm looking for other questions. Would you recommend fighting for written goals for specific curriculum? Okay. School districts will not write for specific curriculum because they often make curriculum changes, or they'll often pull multiple curriculums to work with a student. So well-written goals would work. If I wrote a good goal for Barton, it would also work for the Wilson Reading System. It could also work in other curriculums as well. I can write a wired for reading goal that crosses all curriculum without difficulty. So well-written goals do not have to be curriculum dependent. Okay, what are your thoughts on substantiating 0% as the present level data point for an IEP goal? If you are at 0% accuracy, the material is too difficult for the student and you're not getting an accurate picture. You have got to go back farther and find a lower level to determine where the start point is for that student. Once you get below 50%, the accuracy of your measure is deeply called into question. And so they need to keep going backwards until you get, in my mind, a minimum threshold of about 50% as a start point. Okay, the two tests are the Wilson Assessment of Encoding and Decoding and the Qualitative Reading Inventory. It's currently in its 7th edition, but you can find used copies very inexpensively. What services do districts need to provide for dyslexia and dysgraphia? Is 1-to-1 appropriate, 15 years old, kindergarten level? Okay. So if a student is that regressed, that is where you would make the suggestion to the district that the student needs more intensive time, that 15 minutes or 20 minutes a week is inadequate to catch that student up academically. And so at that point, that is where you want the IEP to have lots of goals that will build skill set. And if they won't write lots of goals, they can provide objectives. Now, not every school district likes to write objectives, but objectives build to goals. So that's an alternative to not have to track 97 goals. Okay. The scope and sequence and the slide deck will be provided. Sarah's got a way to get that out to everybody. As a teacher, I know that we are dealing with poorly written goals and poor data tracking. How can we support families without blowback? So the way you support families is you come back and say, I'm going to write goals in a different way, and I'm going to be more transparent in how I'm collecting that data so that you can better see what's happening and what I'm doing in the classroom. I think teachers should be comfortable coming in and saying, I've learned more, I'm ready to do more. And when parents hear that, it's often a sigh of relief. And so all teachers, good teachers, keep learning or they shouldn't be teaching. And so just come in and say that, okay? I find that a math-based learning disability is a mystery to school staff as much as dyslexia was before. What intervention curriculum would you recommend? Okay. Unfortunately, math is the forgotten child. So with structured literacy, we have lots of different curricular options. We don't have as many options to riff through for math curriculums to offer as alternatives. What I recommend that you do is take a look at skill set and where you want your student to be performing. We have students that math is just not their thing, just like editing is not my thing. Proof, I am not a good proofreader. I'm a good writer. I am not a good proofreader. We need to then identify what our long-term goals are for that student in terms of functional math. Do I understand money? Can I balance my checking account? Can I go to a store and understand a % off coupon? Do I understand conversions? Do I understand area? Really looking at functional life skills in terms of math begins to drive then how you write math goals. There are a couple resources out there. I will provide Sarah my materials list in math to give you some ideas. There's a great book called When Are We Ever Going to Use This? That talks about real life math applications as a nurse, as a mechanic, as a nothing else is coming to mind at the moment. So there are places to go for that. What growth is acceptable per quarter? If a child is obviously not meeting the goal 100% before you make a stink. So if a goal is well written, let's say we had a student that was reading 20 out of 40 words correct based on syllable types and being phonetically regular. I would expect a teacher to come in and say, here are the syllable types I've taught, and here's the accuracy of them reading those syllable types. Here's the next syllable type that is coming along. And so if I've written, a student will be able to do 2 to 3 closed, open, vowel, consonant, E syllable types with 95% accuracy, and this is not a well-written goal, I'm just spouting it, within a bank of 40 words, they should be able to come back in and say, we're on 2 syllable with these syllable types, and this is their accuracy on that reading list. I did share with Sarah another handout, which are some sample IEP goals that I've drafted that are not perfect by any stretch of the imagination, but it gives you a starting point to look and think about how you would write another goal. I think we've got time for one more question, and then we should be done. I saw one about 15 minutes of SDI for reading and writing, specially designed instruction. That is too low. And that is a more in-depth, detailed conversation. That's a good time to find an advocate. And then the Wilson reading system goes down to kindergarten. And with that, I'm going to stop taking questions. Does anybody, Cheryl-Ann, do you need to say anything else?
This is Sherilyn. Thank you so much, Mindy. That's all right. And I did just put in a request for donations for anyone who can. Most of what we do in our fundraising for the PTSA is put the dollars back into accessibility for ASL interpretation and ideally for additional languages. And with that, and I'm looking back at the clock to make sure we maximize it, our interpreter gets to say goodnight at 8 o'clock.
Did an
I'm
amazing
going to ask
job.
you perhaps just one more question because I know there's so many topics. Let's take one more question and then we'll close it. Thank you.
Is anybody else seeing one really quick that you're scrolling through?
This is Yana. I'm not scrolling, but I do have a quick question that I asked in the chat before, and I'm not sure if either one of you is going to be able to respond, but I was wondering if with the burden of proof shifting for due process, if we could possibly make that argument that with OSBI, that the burden of proof needs to also shift for special education community complaints, because what we are seeing is oftentimes the parent will say, this is what my child is reporting. I have that experience also, not just with my children, but my child saying this is not happening or this is happening. And then the district's attorney will say, it's actually was not happening or, contradicts, and then OSBI believes them. And I'm sorry, it's 8 o'clock, but I think if we could take like 1 minute, at least like a brief response, that would be wonderful.
Nicole, I'm going to toss that one to you.
Sure. And so that would have to be addressed through the rulemaking process. So the Office of lots of acronyms. OSPI, Office of the Superintendent of Public Instruction, has its own rules about how it handles community complaints that don't come from our laws, they don't come from federal law, they don't come from state law, they have their own internal procedures. And so a lot of the way that they conduct them, is a mystery. Where do they find their investigators? What process do they use? Sometimes we don't know about what goes on behind the scenes unless we get a records request and start looking into it. And so I think this is an important advocacy point, for your PTAs to think about. Is this process fair and transparent? I know at a national level, the Council of Parent Attorneys and Advocates is doing a nationwide sort of data collection and advocacy process on how to improve state complaints statewide. So this is not just a problem in our state. Yeah, it's a nationwide problem. So I encourage you to look for advocacy opportunities in that area.
This is Cheryl Lynn, and thank you. I allowed a little extra time and we've gone long. So appreciate it. My understanding, Decoding Dyslexia and Washington branch
of the International
Dyslexia Association will both be working on getting the slides. We'll put them up on our website. I can't say it will be tomorrow, as well as then this video will be available too.
And some additional handouts.
Great. Thank you.
Good night, everybody.
Good night.
Thank you.